This is the Ministry of Truth. I'm Gordon Comstock. I'm still hearing some people reference the Bill of Rights out there as though the Bill of Rights pertained to them. Let's fix that. Let's help the informer fix that. This is the Bill of Rights Fraud, Part 1, written by the informer back in, looks like 2006. He begins with a personal letter. He writes, "After having this case and others for 16 years and posting to the internet with no response, I figured it shook to the core beliefs that people do not accept the facts as stated in numerous legal books, that the Bill of Rights was never intended for the people like you and I in the States. You, of course, like to cite the Constitution and the Bill of Rights all the time, little knowing that in doing so you put yourself at their feet, groveling as a slave would do. This case and others to follow in Part 2, if understood, will show just how corrupt the Founding Fathers were in keeping to themselves the contract between themselves and no others in the States. Just as Lysander Spooner stated, the Constitution was of no authority. Why people have not found out by now shows how good the fraud has been, and how brainwashed the average American is. To keep the articles from becoming too long to digest, I break the whole article into 2 parts. The first part is all the John Barron case with no comments interjected, so I don't make any confusing statements. The Part 2 has a brief injection of my comments. Otherwise, it's all from the Constitutional Law book, to tell you how it will shake your core beliefs to the foundation. I had a paralegal friend here for a visit. I brought up the subject that the Bill of Rights was not for him. He immediately reacted with, "No, it isn't so." Well, I walked to my office and brought out what you will read in Part 2. After reading maybe 5 pages, he said, "No, it can't be. Let me see the Barron case for itself." Now, mind you, he is sharper than most attorneys and other paralegals and did not want to believe what he was reading. So I handed him the Barron case, which you will read here, and it has never been overturned to this day. After reading it, he said, "Why, those beep," expletive deleted. "No wonder why we lost in all cases," he said. I am reading it and still find it hard to believe they would do this. So when he asked, "To whom does it apply?" I brought out various other certified documents and showed him. Then his core beliefs just had an ice-cold ice pick driven through them, and he was shaken up, to say the least. Now, in Part 2, later on, you will read how they incorporated those Bill of Rights into your life, which gave them more control over you than if they hadn't done a thing. Does 14th Amendment mean anything to you? Do you know that only 14th Amendment people can use the Bill of Rights? And when you do invoke any of the original 10 Bill of Rights, you admit to being covered by the 14th, and the Ashwander doctrine will bury you. So beware. You will go into cognitive dissonance, guaranteed, because your core beliefs will be shattered, to say the least, and you will not think the same things you have for all of your life up to this point. If it does sink in what this criminal government has done to all of us today and to all of your family, all the way back to 1776. Signed, The Informer, September 23rd, 2006. And now for that court case, the Barron case. 32 U.S. 243. On writ of error to the Court of Appeals for the Western Shore of the State of Maryland. Syllabus. The provision in the Fifth Amendment to the Constitution of the United States declaring that private property shall not be taken for public use without just compensation is intended solely as a limitation on the exercise of power by the government of the United States and is not applicable to the legislation of the states, capital S. The Constitution was ordained and established by the people of the United States for themselves, capital U, capital S, for their own government, and not for the government of individual states, capital S. Each state, capital S, established a constitution, lowercase c, for itself, and in that constitution, lowercase c, provided such limitations and restrictions on the powers of its particular government as its judgment dictated. The people of the United States, and these are all going to be capital U, capital S, unless I say otherwise, United States, both caps. The people of the United States framed such a government for the United States as they supposed best adapted to their situation and best calculated to promote their interests. The powers they conferred on this government were to be exercised by itself, and the limitations on power, if expressed in general terms, are naturally and necessarily applicable to the government created by the instrument. They are limitations of power granted in the instrument itself, not of distinct governments framed by different persons and for different purposes. This case was instituted by the plaintiff in error against the city of Baltimore under its corporate title of the Mayor and City Council of Baltimore to recover damages for injuries to the wharf property of the plaintiff arising from the acts of the corporation. Craig and Barron, of whom the plaintiff was survivor, were owners of an extensive and highly productive wharf in the eastern section of Baltimore, enjoying, at the period of their purchase of it, the deepest water in the harbor. The city, in the asserted exercise of its corporate authority over the harbor, the paving of streets and regulating grades for paving, and over the health of Baltimore, diverted from their accustomed and natural course certain streams of water which flow from the range of hills bordering the city, and diverted them partly by adopting new grades of streets, and partly by the necessary results of paving, and partly by mounds, embankments, and other artificial means, purposely adapted to bend the course of the water to the wharf in question. These streams, becoming very full and violent in rains, carried down with them from the hills and the soil over which they ran large masses of sand and earth, which they deposited along and widely in front of the wharf of the plaintiff. The alleged consequence was that the water was rendered so shallow that it ceased to be useful for vessels of an important burden, lost its income, and became of little or no value as a wharf. This injury was asserted to have been inflicted by a series of ordinances of the corporation between the years 1815 and 1821, and that the evil was progressive, and that it was active and increasing even at the institution of this suit in 1822. At the trial of the cause in the Baltimore County Court, the plaintiff gave evidence tending to prove the original and natural course of the streams, the various works of the corporation from time to time to turn them in the direction of this wharf, and the ruinous consequences of these measures to the interests of the plaintiff. It was not asserted by the defendants that any compensation for the injury was ever made or proffered, but they justified, under the authority they deduced from the charter of the city, granted by the legislature of Maryland, and under several acts of the legislature, conferring powers on the corporation in regard to the grading and paving of streets, the regulation of the harbor and its waters, and to the health of the city. They also denied that the plaintiff had shown any cause of action in the declaration, asserting that the injury complained of was a matter of public nuisance, and not of special or individual grievance in the eye of the law. This latter ground was taken on exception, and was also urged as a reason for a motion in arrest of judgment. On all points, the decision of Baltimore County Court was against the defendants, and a verdict of $4,500 was rendered for the plaintiff. An appeal was taken to the Court of Appeals, which reversed the judgment of Baltimore County Court and did not remand the case to that court for a further trial. From this judgment, the defendant in the Court of Appeals prosecuted a writ of error to this court. The counsel for the plaintiff presented the following points. The plaintiff in error will contend that apart from the legislative sanctions of the state of Maryland and the acts of the Corporation of Baltimore, holding out special encouragement and protection to interests in wharves constructed on the shores of the Patapsco River, and particularly of the wharf erected by Craig and the plaintiff Barron, the right and profit of wharfage and use of the water at the wharf for the objects of navigation was a vested interest and incorporeal hereditament, inviolable even by the state, lowercase s, except on just compensation for the privation. But the Act of Assembly and the ordinance of the city are relied on as enforcing the claim to the undisturbed enjoyment of the right. This right was interfered with, and the benefit of this property taken away from the plaintiff by the corporation avowedly, as the defense showed, for public use, for an object of public interest, the benefit more immediately of the community of Baltimore, the individuals, part of the population of Maryland, known by the corporate title of the mayor and city council of Baltimore. The quote-unquote inhabitants of Baltimore are thus incorporated by the Acts of 1796, Chapter 68. As a corporation, they are made liable to be sued and authorized to sue to acquire and hold and dispose of property, and, within the scope of the powers conferred by the Charter, are allowed to pass ordinance and legislative acts, which it is declared by the Charter shall have the same effect as acts of assembly, and be operative, provided they be not repugnant to the laws of the state, lowercase s, or the Constitution of the state, lowercase c, lowercase s. I'm not sure why, but that's how it's written here. Or of the United States. Now we get capital U, capital S. The plaintiff will contend accordingly. 1. That the mayor and city council of Baltimore, all caps there, though viewed even as a municipal corporation, is liable for tort and actual misfeasance, and that it is a tort, and would be so even in the state, lowercase s, acting in her immediate sovereignty to deprive a citizen of his property, though for public uses without indemnification, that regarding the corporation as acting with the delegated power of the state, lowercase s, the act complained of is not the less an actionable tort. 2. That this is the case of an authority exercised under a P asterisk 246 state, capital S, the corporation appealing to the legislative acts of Maryland for the discretional power which it has exercised. 3. That this exercise of authority was repugnant to the Constitution, lowercase c, of the United States, contravening the 5th article of the amendments to the Constitution, lowercase c again, not sure why, which declares that, quote, private property shall not be taken for public use without just compensation, unquote. The plaintiff contending that this article declares principles which regulate the legislation of the states, lowercase s, for the protection of the people, lowercase p, in each and all the states, lowercase s, regarded as citizens of the United States, capital U, capital S, or as inhabitants subject to the laws of the Union, capital U. That under the evidence, prayers, and pleadings in the case, the constitutionality of this authority exercised under the state must have been drawn in question, and that this court has appellate jurisdiction of the point from the judgment of the Court of Appeals of Maryland, the highest court of that state, lowercase s, that point being the essential ground of the plaintiff's pretension in opposition to the power and discussion of the corporation. 5. That this court, in such appellate cognizance, is not confined to the establishment of an abstract point of construction, but is empowered to pass upon the right or title of either party, and may therefore determine all points incidental or preliminary to the question of title and necessary in the course to that inquiry, that, consequently, the question is for this court's determination whether the declaration avers actionable matter, or whether the complaint is only of a public nuisance, and on that head the plaintiff will contend that special damage is fully shown here, within the principle of the cases where an individual injury resulting from a public nuisance is deemed actionable, the wrong being merely public, only so long as the law suffered in the particular case is no more than all members of the community suffer. Upon these views, the plaintiff contends that the judgment of the Court of Appeals ought to be reversed. Opinions. Mr. Chief Justice Marshall delivered the opinion of the court. Marshall, C.J., opinion of the court. The judgment brought up by this writ of error, having been rendered by the court of a state, capital S, this tribunal can exercise no jurisdiction over it unless it be shown to come within the provisions of the 25th section of the Judiciary Act. The plaintiff in error contends that it comes within that clause in the Fifth Amendment to the Constitution, capital C, which inhibits the taking of private property for public use without just compensation. He insists that this amendment, being in favor of the liberty of the citizen, ought to be so construed as to restrain the legislative power of a state, as well as that of the United States. If this proposition be untrue, the court can take no jurisdiction of the cause. The question thus presented is, we think, of great importance, but not of much difficulty. The Constitution, capital C, was ordained and established by the people of the United States for themselves. The P in people is lowercase there, interestingly. For their own government, and not for the government of the individual states, capital S. Each state, capital S, established a constitution, lowercase c, for itself, and in that constitution provided such limitations and restrictions on the powers of its particular government as its judgment dictated. The people of the United States framed such a government for the United States as they supposed best adapted to their situation and best calculated to promote their interests. The powers they conferred on this government were to be exercised by itself, and the limitations on power, if expressed in general terms, are naturally, and we think necessarily, applicable to the government created by the instrument. They are limitations of power granted in the instrument itself, not of distinct governments framed by different persons and for different purposes. If these propositions be correct, the Fifth Amendment must be understood as restraining the power of the general government, both capital G's there, not as applicable to the states, capital S. In their several constitutions, capital C, they have imposed such restrictions on their respective governments as their own wisdom suggested, such as they deemed most proper for themselves. It is a subject on which they judge exclusively, and with which others interfere no further than they are supposed to have a common interest. The counsel for the plaintiff in error insists that the Constitution, capital C, was intended to secure the people, lowercase p, of the several states, capital S, against the undue exercise of power by their respective state governments, capital S, as well as against that which might be attempted by their general government, capital G, capital G. In support of this argument, he relies on the inhibitions contained in the 10th section of the first article. We think that section affords a strong, if not a conclusive, argument in support of the opinion already indicated by the court. The preceding section contains restrictions which are obviously intended for the exclusive purpose of restraining the exercise of power by the departments of the general government, capital G's again. Some of them use language applicable only to Congress. Others are expressed in general terms. The third clause, for example, declares that, quote, no bill of attainder or ex post facto law shall be passed, unquote. No language can be more general, yet the demonstration is complete that it applies solely to the government, capital G, of the United States, capital U, capital S. In addition to the general arguments furnished by the instrument itself, some of which have been already suggested, the succeeding section, the avowed purpose of which is to restrain state legislation, capital S, contains in terms the very prohibition. It declares that, quote, no state, capital S, shall pass any bill of attainder or ex post facto law, unquote. This provision, then, of the 9th section, however comprehensive its language, contains no restriction on state legislation, capital S. The 9th section, having enumerated, in the nature of a Bill of Rights, nothing's capitalized there, the limitations intended to be imposed on the powers of the general government, the 10th proceeds to enumerate those which were to operate on the state legislatures, capital S. These restrictions are brought together in the same section and are by express words applied to the states, capital S. Quote, no state, capital S, shall enter into any treaty, unquote, etc. Perceiving that in a constitution, lowercase c, framed by the people, lowercase p, of the United States, for the government of all, no limitation of the action of government on the people, lowercase p, would apply to the state government, capital S, unless expressed in terms, the restrictions contained in the 10th section are in direct words so applied to the states, capital S. It is worthy of remark, too, that these inhibitions generally restrain state legislation, capital S, on subjects entrusted to the general government, capital G's again, or in which the people of all the states feel an interest, capital S. A state, capital S, is forbidden to enter into any treaty, alliance, or confederation. If these compacts are with foreign nations, they interfere with the treaty-making power, which is conferred entirely on the general government. If with each other for political purposes, they can scarcely fail to interfere with the general purpose and intent of the Constitution, capital C. To grant letters of marque and reprisal would lead directly to war, the power of declaring which is expressly given to Congress. To coin money is also the exercise of a power conferred on Congress. It would be tedious to recapitulate the several limitations on the powers of the states, capital S, which are contained in this section. They will be found generally to restrain state legislation on subjects entrusted to the government of the Union, in which the citizens of all the states are interested. These are all capital S's. In these alone were the whole people concerned. The question of their application to states is not left to construction. It is averred in positive words. If the original Constitution, capital C, in the 9th and 10th sections of the first article, draws this plain and marked line of discrimination between the limitations it imposes on the powers of the general government and on those of the state, if in every inhibition intended to act on state power, words are employed which directly express that intent, some strong reason must be assigned for departing from this safe and judicious course in framing the amendments before that departure can be assumed. We search in vain for that reason. Had the people of the several states, lowercase p, capital S, or any of them required changes in their constitutions, capital C, had they required additional safeguards to liberty from the apprehended encroachments of their particular governments, the remedy was in their own hands, and could have been applied by themselves. A convention could have been assembled by the discontented state, capital S, and the required improvements could have been made by itself. The unwieldy and cumbrous machinery of procuring a recommendation from 2/3 of Congress and the assent of 3/4 of their sister states, capital S, could never have occurred to any human being as a mode of doing that which might be effected by the state itself. Had the framers of these amendments intended them to be limitations on the powers of the state governments, all capital S's again, they would have imitated the framers of the original Constitution and have expressed that intention. Had Congress engaged in the extraordinary occupation of improving the constitutions of the several states by affording the people additional protection from the exercise of power by their own governments in matters which concerned themselves alone, they would have declared this purpose in plain and intelligible language. But it is universally understood, it is a part of the history of the day, that the great revolution which established the Constitution of the United States was not effected without immense opposition. Serious fears were extensively entertained that those powers which the patriot statesmen, who then watched over the interests of our country, deemed essential to union and to the attainment of those invaluable objects for which union was sought, might be exercised in a manner dangerous to liberty. In almost every convention by which the Constitution was adopted, amendments to guard against the abuse of power were recommended. These amendments demanded security against the apprehended encroachments of the general government, not against those of the local governments. In compliance with a sentiment thus generally expressed, to quiet fears thus extensively entertained, amendments were proposed by the required majority in Congress and adopted by the states. These amendments contain no expression indicating an intention to apply them to the state governments. This court cannot so apply them. We are of the opinion that the provision in the Fifth Amendment to the Constitution, declaring that private property shall not be taken for public use without just compensation, is intended solely as a limitation on the exercise of power by the government of the United States, and is not applicable to the legislation of the states. Bingo! There you have it, folks. This is why this guy lost this case. The Bill of Rights does not apply to him. We are therefore of opinion that there is no repugnancy between the several acts of the General Assembly of Maryland, given in evidence by the defendants at the trial of this cause in the court of that state, and the Constitution of the United States. This court therefore has no jurisdiction of the cause, and it is dismissed. This cause came on to be heard on the transcript of the record from the Court of Appeals for the Western Shore of the State of Maryland, and was argued by counsel. On consideration whereof, it is the opinion of this court that there is no repugnancy between the several acts of the General Assembly of Maryland, given in evidence by the defendants at the trial of this cause in the court of that state, and the Constitution of the United States, whereupon it is ordered and adjudged by this court that this writ of error be, and the same is hereby dismissed for the want of jurisdiction. This is the end of Part 1 of the Bill of Rights fraud. Let me read to you that most significant sentence here one more time before we take a break and then come back and do Part 2. Okay, here we go. We are of opinion that the provision in the Fifth Amendment to the Constitution declaring that private property shall not be taken for public use without just compensation is intended solely as a limitation on the exercise of power by the government of the United States, and is not applicable to the legislation of the states. We're going to take a break and come back with Part 2. Here we go. We're back. This is Part 2 of the Bill of Rights fraud by the Informer, written 3 or 4 years ago. It again begins with a letter from the Informer from 2006, November. The following is gleaned from a book called Cases in Constitutional Law, last published 1976, Library of Congress card number 68-18704 by Robert E. and Robert F. Cushman. It contains 159 cases, and over 100 cases commented on or referred to in the 159 cases. The book is 1,168 pages. The book tells you how the Bill of Rights was nationalized. I conversed with a friend named Fred and wrote this to him concerning another patriot that debunked my findings when he would not let the truth sink into his core beliefs. Since then he has capitulated and now sees it, but it took him over 6 years to come to terms with the fraud, realizing it has been a fraud all along. All the bold type herein, in Part 2, is straight out of the book. My comments are a regular type. Hopefully, after reading these 2 parts, you will come to realize that Lysander Spooner was right. The con job was just that, a con job of immense proportions. How the fraud lived so long is only due to the fact our family tree parents, going back to 1776/1787, were led by the nose, as are the people of today. You have to have a core belief, and that, my friends, is based upon a lie. So, as all foundations are either true or false, hopefully you will find what you have been brought up to believe is one huge fraud. Signed, the Informer. So the following is going to alternate between the words of the Informer and what he is gleaning from the book Cases in Constitutional Law from 1967. So I will let you know whose words are whose as we go through. Actually, it looks like the text itself will do that. Okay. The Informer writes, "Hi, Fred. Well, now that I let off some steam, here is more on Barron. It wasn't just as someone we know said that the Supreme Court brought it up in 2001. More garbled syntax from the Informer, I apologize. They brought Barron up way before 2001. I have a constitutional law book titled Cases in Constitutional Law. It is ripe. I think he means rife. It is rife with cases on Barron and many more in its 1,168 pages of knowledge. There are cases that they did not bring up that are just as important, one being Hepburn and Dundas versus Elise, 2 Cranch 445. The heading of the case states, quote, "A citizen of the District of Columbia cannot maintain an action against a citizen of Virginia in the Circuit Court for the District of Virginia. A citizen of the District of Columbia is not a citizen of a state, lowercase s, within the meaning of the Constitution," unquote. Back to the Informer's words. Reading this, it goes way over people's heads and they are not aware. As James Montgomery found out, President Washington created the states as districts in 1791. That's a lowercase s there for states, too. Hence the phrase District of Virginia in the above case. It is an important case, and you must get it because it is ripe. The Informer means rife. It is rife with info that will wipe out the myth that people have had on the jurisdiction. A passage in the case so states after the court gets rid of the notion that the people of the states, all lowercase there, are on the same footing as the people of the District of Columbia, and said the plaintiff could not sue in Virginia. This is the defense position statement. Here comes another quote from the Cases in Constitutional Law. Quote, "Even if the Constitution of the United States authorizes a more enlarged jurisdiction than the Judiciary Act of 1789 has given, yet the court can take no jurisdiction which it is not given by the Act. I, therefore, call for the law which gives a jurisdiction in this case," unquote. Back to the Informer. A response was given by plaintiff to rebut the above statement. The court then gave its decision and sided with defense when Chief Justice Marshall said, quote, "The opinion to be certified to the Circuit Court is that that court has no jurisdiction in the case," unquote. Back to the Informer. So basically, the Judiciary Act of 1789 gives what jurisdiction the federal courts have. Not the Congress, as so many people believe. And as the defense attorney said, if it's not to be found, jurisdiction, in that act, the federal court does not have it. Here we have direct admission that lawyers back then were dictating the parameters in which the courts had jurisdiction. The Informer, in his New History, brought this up when he cited the History of the American Bar by Charles Warren. I believe you have that book by the Informer. Might pay to reread it in light of this revelation the guy I was talking about had. Now back to Barron. In the Notes of the Constitutional Cases book, printed in 1968, it states, quote, "While most rights in the Bill of Rights now do apply to the states, lowercase s, they do so only because they are essential to due process of law. The ruling in the present case that the Bill of Rights does not apply directly to the states, lowercase s, has never been overruled," unquote. Brown versus Walker, 1896. Barron was again broached on self-incrimination case. The book had this to say, quote, "In 1956, the court reaffirmed the Brown decision in Ullman versus United States. It rejected the defendant's argument that, quote, the impact of the disabilities imposed by federal and state authorities and the public in general, such as loss of job, expulsion from labor unions, state registration and investigation statutes, passport eligibility, and general public opprobrium, is so oppressive that the statute does not give him true immunity." Unquote. The statute, like the Fifth Amendment provision, protects the witness only from having to give testimony which may possibly expose him to a criminal charge. Since Congress need not grant immunity from state prosecution in order to compel testimony, the question arises whether it may do so if it wishes. The control over evidence admissible in state courts, lowercase s, is traditionally a question of state power, lowercase s again, and even the Supreme Court, in administering the Due Process Clause, has been reluctant to interfere with this state prerogative. In Adams versus Maryland, 1954, the court held that Congress could, under the supremacy doctrine, forbid a state to use testimony given before a congressional committee. Adams had been summoned before the Senate Crimes Investigation Committee and had bared his soul concerning his activities. The state of Maryland, which had been unable to get other evidence against Adams, read the transcript of the committee hearing into the trial record as a confession, and he was convicted of illegal gambling. The Supreme Court reversed the conviction on the ground that 859 forbade the use of such testimony in any criminal proceeding against him in any court. While Congress could not compel testimony under the statute, such testimony as was given was protected, and the phrase "in any court" included state courts as well as federal. Forbidding such use of the testimony was held to be a necessary and proper way of securing testimony. The Immunity Act of 1954 uses this same language, and the Adams interpretation was reaffirmed by the court in the Ullman case. In the present case, a federal grand jury was investigating charges against a railroad that it had granted discriminatory rates and rebates. Brown, who was an officer of the railroad, was called as a witness, but refused to answer certain questions on the ground that the answers would tend to accuse and incriminate him. He was adjudged in contempt for his refusal to answer. Mr. Justice Brown delivered the opinion of the court, saying, in part, "It is true that the Constitution does not operate upon a witness testifying in state courts. Since we have held that the first 8 amendments are limitations only upon the powers of Congress and the federal courts, and are not applicable to the several states, except so far as the 14th Amendment may have made them applicable." See Barron versus Baltimore, 1833. There is no such restriction, however, upon the applicability of federal statutes. The court here quotes the Supremacy Clause in Article 6. The act in question contains no suggestion that it is to be applied only to the federal courts. It declares broadly that no person shall be excused from attending and testifying before the Interstate Commerce Commission on the ground that the testimony required of him may tend to incriminate him, etc. But no person shall be prosecuted or subjected to any penalty or forfeiture for or on account of any transaction, matter, or thing concerning which he may testify, etc. It is not that he shall not be prosecuted for or on account of any crime concerning which he may testify, which might possibly be urged to apply only to crimes under the federal law. But the immunity extends to any transaction, matter, or thing concerning which he may testify, which clearly indicates that the immunity is intended to be general and to be applicable whenever and in whatever court such prosecution may be had. But even granting that there were still a bare possibility that by his disclosure he might be subjected to the criminal laws of some other sovereignty, that is not a real and probable danger with reference to the ordinary operations of the law in the ordinary courts, but a danger of an imaginary and unsubstantial character, having reference to some extraordinary and barely possible contingency, so improbable that no reasonable man would suffer it to influence his conduct. Such dangers it was never the object of the provision to obviate. The same answer may be made to the suggestion that the witness is imperfectly protected by reason of the fact that he may still be prosecuted and put to the annoyance and expense of pleading his immunity by way of confession and avoidance. This is a detriment which the law does not recognize. There is a possibility that any citizen, however innocent, may be subjected to a civil or criminal prosecution and put to the expense of defending himself, but unless such prosecution be malicious, he is remediless, except so far as a recovery of costs may partially indemnify him. While the constitutional provision in question is justly regarded as one of the most valuable prerogatives of the citizen, its object is fully accomplished by the statutory immunity, and we are therefore of opinion that the witness was compellable to answer, and that the judgment of the court below must be affirmed. Mr. Justice Shiras, with whom Mr. Justices Gray and White concurred, wrote a dissenting opinion. Mr. Justice Field wrote a separate dissent. Unquote. In Powell v. Alabama, 1932, Barron was brought up again. Then in Palco v. Connecticut, 1937, Barron was brought up again, and this is the book's comment. Quote, with the decision in Powell v. Alabama, it appeared that the long struggle to nationalize the Bill of Rights might at last be bearing fruit. The court had acknowledged that it no longer felt bound by the Hurtado reasoning. The application to the states of the Fifth Amendment right to just compensation and the Fifth Amendment rights of free speech, press, religion, and assembly showed that some of the Bill of Rights guarantees could be applied to the states through due process of law. Lowercase s for states there. And now in Powell, the court for the first time had found one of the rights of persons accused of crime to be essential to due process. The Palco case, printed below, made clear that the court was not prepared to abandon earlier decisions, such as Hurtado and Twining. Instead, it undertook to explain why some rights, such as the rights to counsel and free speech, are absorbed into due process, and why others, like jury trial and grand jury indictment are not. It should be emphasized that the case is, quote-unquote, absorbing rights into the 14th Amendment. There's your due process. They do not overrule Barron versus Baltimore, 1820. There you go. There it is. The provisions of the Federal Bill of Rights still limit directly only the federal government. There it is. It is the 14th Amendment which limits the states. What the court has done is to reverse the practical effect of the rule in Barron versus Baltimore with respect to part, but not all, of the Bill of Rights. Some of these rights are still not considered by the court to be so fundamental as to be required by due process of law. You hear that, folks? The court, in case after case, has been classifying the provisions. Again, folks, these are not the words right now of the informer. This is from cases in constitutional law, okay? So let me find where I was at. Oh, man. The court, in case after case, has been classifying the provisions of the Bill of Rights into those which are essential to due process of law and thus bind the states through the, lowercase s, through the operation of the 14th Amendment, and those which are not essential to due process and by which the states are not bound. In effect, the court has established a quote-unquote honor roll of superior rights which bind both state and national governments. The opinion in the present case is important since it gives an official summary of this classification up to 1937 and states clearly the principles on which the classification rests. In another situation, and for a very different purpose, the court classified the provisions of the Federal Bill of Rights. In fixing the constitutional status of territories after the war with Spain, the court held that in governing unincorporated territories, such as Puerto Rico and the Philippines, Congress was restricted only by those guarantees in the Bill of Rights which are basic and fundamental, and not by those which are merely procedural or remedial, such as the guarantee of trial by jury. See Balzac versus Puerto Rico, 1922. This classification is essentially the same as that in Palco versus Connecticut. One question which the Palco case failed to answer satisfactorily was what was meant by absorption or incorporation of a Bill of Rights guarantee into due process. Did it mean that the right, as listed in the Bill of Rights and interpreted by the Supreme Court in federal cases, was made applicable to the states? Or was the right, as applied to the states, a more general right, less clearly defined, and permitting more leeway and discretion on the part of the states, lowercase s? Clearly, incorporation of the First Amendment has meant its application to the states exactly as it applied to the national government. Justices Brandeis and Holmes, in their dissent in the Gitlau case, suggested that the free speech applicable to the states perhaps, quote, may be accepted with a somewhat larger latitude of interpretation than is allowed to Congress by the sweeping language that governs or ought to govern the laws of the United States, unquote. The court, however, has never acknowledged such a distinction, and the same rules for deciding such cases are applied to the states and the nation alike. With the gradual extension of due process to include other rights, an important controversy developed as to how these rights would apply to the states. These are all lowercase s's still. This problem is discussed in connection with the specific rights in the chapter below. Unquote. And the informer writes, another case is United States versus Lanza, 1922. This is what the court stated. Then I will go to the book comments and bear in mind what happened at the Ruby Ridge trial against the government agent and put into that what the book states. Chief Justice Taft delivered the opinion. Quote, we have here two sovereignties deriving power from different sources, capable of dealing with the same subject matter within the same territory. Each may, without interference by the other, enact laws to secure prohibition, with the limitation that no legislation can give validity to acts prohibited by the amendment. Each government, in determining what shall be an offense against its peace and dignity, is exercising its own sovereignty, not that of the other. It follows that an act denounced as a crime by both national and state sovereignties is an offense against the peace and dignity of both, and may be punished by each. The Fifth Amendment, like all the other guarantees in the first 8 amendments, applies only to proceedings by the federal government, as seen in Barron versus Baltimore, 1833. There you go. And the double jeopardy therein forbidden is a second prosecution under authority of the federal government after a first trial for the same offense under the same authority. Here the same act was an offense against the state of Washington, because a violation of its law, and also an offense against the United States under the National Prohibition Act. The defendants thus committed 2 different offenses by the same act, and a conviction by a court of Washington of the offense against that state is not a conviction of the different offense against the United States, and so is not double jeopardy. Wow, these lawyers hiding the keys of knowledge, you dirty scumbags. They're justifying double jeopardy here by playing legalist word games out of legalese. If Congress sees fit to bar prosecution by the federal courts for any act when punishment for violation of state prohibition has been imposed, it can, of course, do so by proper legislative provision. But it has not done so. If a state were to punish the manufacture, transportation, and sale of intoxicating liquor by small or nominal fines, the race of offenders to the courts of that state to plead guilty and secure immunity from federal prosecution for such acts would not make for respect for the federal statute or for its deterrent effect. But it is not for us to discuss the wisdom of legislation. It is enough for us to hold that, by the way, this is a skull and boner here, giving this double-tongued argument here is Justice Taft. It is enough for us to hold that, in the absence of special provision by Congress, conviction and punishment in a state court under a state law for making, transporting, and selling intoxicating liquors is not a bar to prosecution in a court of the United States under the federal law for the same acts. Judgment reversed. Now, for the comment by the book, writes the informer. Quote, it was one of the universal maxims of the common law that no man should be brought into jeopardy of his life more than once for the same offense. Protection against double jeopardy is guaranteed by the Fifth Amendment against invasion by the federal government, while a similar clause is found in the Bill of Rights of most of the state constitutions. A person is held to be in jeopardy when his trial has progressed to the point where he actually confronts the jury. If convicted, he may waive his immunity from double jeopardy by an appeal to a higher court, which may allow him a new trial. But if acquitted, further proceedings against him by the prosecuting authorities are barred, the government not even being allowed to appeal the case on the ground of error of law. See United States v. Sanchez, 1892. Moreover, if he appeals his conviction and is granted a new trial, the defendant can only be retried on the charge of which he was convicted. Thus, in Green v. United States, 1957, a person who was indicted and tried for first-degree murder, but was found guilty by the jury of second-degree murder, could not, after successfully appealing the second-degree murder charge, be retried on the original charge of first-degree murder. He had already been once in jeopardy for that crime, and had not waived his protection by appealing his conviction for a different crime. In certain recognized circumstances, a court can declare a mistrial and subject the accused to a second trial without violating the protection against double jeopardy. This is true where it turns out that a juror is disqualified. See Thompson v. United States, 1894, and in United States v. Perez, 1824, it was held permissible where the jury could not agree on a verdict. Quote, "The prisoner has not been convicted or acquitted and may again be put upon his defense. We think that in all cases of this nature, the law has invested courts of justice with the authority to discharge a jury from giving any verdict whenever, in their opinion, taking all the circumstances into consideration, there is a manifest necessity for the act, or the ends of public justice would otherwise be defeated. They are to exercise a sound discretion on the subject, and it is impossible to define all the circumstances which would render it proper to interfere." Unquote. The double jeopardy clause would prevent declaring a mistrial and ordering a new trial solely to permit the government more time to secure evidence against the accused. In Downham v. United States, 1963, the government asked that the jury be discharged when it discovered two of its key witnesses were missing. 2 days later, a new jury was impaneled, and Downham was convicted. The court conceded that a new jury could be impaneled after the discharge of the first, where there is an imperious necessity to do so, or in very extraordinary and striking circumstances. Here the government had simply started the trial before it had located all its witnesses. A move such as this does not, however, amount to a denial of due process when done in a state court. In Brock v. North Carolina, 1953, the state court had declared a mistrial and ordered a continuance of the case in order to permit the state to deal with some of its own witnesses who had unexpectedly refused to testify on pleas of self-incrimination. Citing the Palco case, the court held that the double jeopardy provision was not incorporated into the 14th Amendment, and this particular action was not shocking enough to make the trial unfair. In 1967, the court declined to decide whether or not the double jeopardy provision of the Fifth Amendment would be extended to the states, although it had granted certiorari to decide the question. On a full hearing of the case, it agreed that the state action did not amount to double jeopardy and dismissed the writ as improvidently granted. See Cichos versus Indiana. Since one is not in jeopardy until his trial actually begins, indictment for crime does not put a person in jeopardy, and therefore repeated indictments do not constitute double jeopardy. Moreover, the government can appeal the dismissal of an indictment, and such an appeal gives the Supreme Court an opportunity to pass upon the constitutionality of criminal legislation which a lower court holds unconstitutional. See the discussion in the note to Muskrat versus United States. It does not constitute double jeopardy to try a person each time he commits the same offense over again. Thus, a conscientious objector who has sowed a prison sentence for refusing to register for the draft may be tried and convicted again if he continues in his refusal. Brilliant, brilliant lawyer shenanigans there. Hiding the keys of knowledge. And putting burdens upon the people that you would never even deign to carry yourself. The same is true of a person who is punished for contempt for refusing to give testimony, where, however, a witness is asked to identify a person as a communist and in reply refuses to so identify anyone. She is guilty of only one contempt, despite a refusal to answer the same question asked 11 times with regard to other persons. See Yates versus United States, 1957. More word games. Wow. Where Congress has made conspiracy to commit a felony a separate crime from the commission of the felony itself, a person may be tried for both crimes. Whether the second trial constitutes double jeopardy in cases like this depends on the nature of the evidence needed to convict. The court in Morgan v. Devine, 1915, quoted with approval from Bishop on Criminal Law, which reads, "The test is whether, if what is set out in the second indictment had been proved under the first, there could have been a conviction. When there could, the second cannot be maintained. When there could not, it can be." One of the obvious results of living under our federal form of government is that every person is subject to the criminal jurisdiction of two separate governments. Brilliant. The state and the national. It is entirely possible, therefore, for a single act to constitute an offense against the statutes of the United States and at the same time to be punishable under state law. This is true in the case of counterfeiting the national currency, corrupt practices in the conduct of congressional elections, assaults against federal officers, the larceny of goods moving in interstate commerce, violations of the former Prohibition Amendment, etc. In these cases, it has long been held that a person may be tried and punished by both governments without violating the protection against double jeopardy. Why don't they just come out and say it? We have double jeopardy in this country. Why can't the lawyers just deal straight one time? That guarantee is violated only by a second trial for the same offense against the same sovereignty, not by a trial or the same act when it constitutes a separate and distinct crime against another sovereign. This doctrine had, of course, considerable practical effect in connection with the enforcement of the Prohibition Amendment, under which concurrent jurisdiction rested in the state and national governments. Note the similarity of this rule to the one applied to the self-incrimination cases. In the present case, Lanza had been convicted by the state courts of Washington for violating the State Prohibition Act. He was then indicted in a federal court for the same act, which also violated the Volstead Act. The district judge dismissed the indictment on the ground of double jeopardy, and the government appealed. The Lanza rule, though sharply criticized, still stands. Abate v. United States, 1959, held that a man convicted of a crime in Illinois could later be tried for the same act, in this case dynamiting telephone communications, under a federal law. Lanza was specifically reaffirmed by a 6-3 decision. On the same day, the court held 5-4 that one acquitted in a federal court of robbing a federally insured bank could later be tried and convicted in a state court for the same robbery. See Bartkus v. Illinois, 1959. While the Lanza rule has a logical persuasiveness about it, and the court has done nothing to weaken it, it has not been given wide application. It is not, for example, followed in international law. As early as 1820, the Supreme Court recognized that while all states could try a person for piracy, there can be no doubt that the plea of autrefois acquit would be good in any civilized state, though resting on a prosecution in the courts of any other civilized state. See United States v. Furlong. Nor has the court felt the rule should apply in cases where two states have concurrent jurisdiction, as on the Columbia River, where Washington and Oregon both have jurisdiction over the entire river, so as to avoid any nice question as to whether a criminal act sought to be prosecuted was committed on one side or the other of the exact boundary in the channel. Where an act is prohibited and punishable by the laws of both states, the court commented, "The one first acquiring jurisdiction of the person may prosecute the offense, and its judgment is a finality in both states, so that one convicted or acquitted in the courts of the one state cannot be prosecuted for the same offense in the courts of the other." See Nielsen v. Oregon, 1909. The manifest unfairness of the Lanza rule has been widely recognized, and following the Abate and Bartkus decisions, the Attorney General of the United States ordered that no federal case should be tried when there has already been a state prosecution for substantially the same act or acts without the United States Attorney first submitting a recommendation to the appropriate assistant attorney general in the department. So they're making it up as they go along, basically. And they always have been. They're lawyers. What did Jesus say about them? And in Petit versus United States, 1960, Petit, a lawyer in deportation proceedings against the same man held in both Philadelphia and Baltimore, induced his client to swear falsely that he had been born in the United States. For this suborning of perjury, he was convicted. He should have been president. I mean, Clinton can get away with that, so why couldn't this guy? You needed to be president, is what you needed to be. For this suborning of perjury, he was convicted and punished in the Federal District Court in Pennsylvania, and later in the Federal District Court in Maryland. When the case came to the Supreme Court, the Solicitor General moved that the second judgment be vacated and the indictment dismissed. He contended that the double jeopardy clause had not been violated, but stated that the initiation of the second prosecution in this case was contrary to sound policy, and for that reason, and in the interests of justice, the indictment should be dismissed. The Supreme Court, without passing on the double jeopardy question, granted the motion, unquote. And now we finish up with one final short paragraph from the Informer. So there, Fred, is the story. Now I think this fellow I was talking about has a lot of cognitive dissonance and ego to get rid of. And it just might take him more than 3 months to understand. After all, I would say he is at least 12 years behind the Informer's knowledge. I'm not sure whether the Informer is talking about himself in third person here. Don't know. Well, once he obtains the level of competence that we have obtained, then he is on, well, he shouldn't be talking about ego, writing about this then that we have obtained, then he is on to better things and won't be so ego-centered. Sounds like the pot calling the kettle black here. It is nice to be eating humble pie once in a while. I think everyone has a lot to learn from reading this and the cases if they so choose. But they need interpretation like this book gives. Because after all, it's what they interpret as ruling, not us. We are only slaves, remember? Boy, he's right about that. And that finishes up parts 1 and 2 of the Bill of Rights Fraud by the Informer. The Bill of Rights does not pertain to you, common American slave. Forget about it. I'm Gordon Comstock. This has been the Ministry of Truth.